So, for the benefit of the recording, this is a free webinar called Everything Domestic Abuse Workers Need to Know About Homelessness Law. We are mis-selling it slightly. Obviously, we're not going to tell you everything you need to know, but hopefully there'll be enough stuff in here that will just kind of help people in everyday situations. Because the law itself is pretty darn good. The problem is that local authorities across the country still don't follow it, and that leads to all kinds of problems. But it does mean that you can have some pretty good wins if you just know a little bit and are willing to challenge councils. So, yeah, this is our disclaimer. It's not that we don't believe what we're saying is correct. It's just that the law does change a little bit over time. And also, just to say from the off as well, that neither Will or I are domestic abuse specialists or anything like that. We know homelessness law because that's our bag. But there will be stuff within the stuff we cover today which involves complexities around domestic abuse and that sort of thing, which we're not going to pretend we know more than you guys. We're not going to try and teach you to suck eggs or anything like that. I guess what we're looking to do here is just break apart some basic stuff about homelessness law, rewrite some myths, because both Will and I basically have jobs because there's loads of myths out there that people just kind of presume about homelessness law that aren't actually true. And as I say, we're going to cover some resources as well that will kind of help you go forward. So things like average waiting times, a good resource, things like the local government social care ombudsman database, are all ways that you can consolidate information that we're going to introduce today. So yeah, in terms of introductions, my name is Mike. I've worked in the homelessness sector for 20 years in Bedford, which is 50 miles north of London, if you're wondering. And the first, I don't know, 10 years of my career has basically been focused on so-called single homeless people, so people without children, and mostly in like night shelter settings, rough sleeper settings. So most of my kind of my kind of introduction to the sector was working with people who would otherwise be rough sleeping. Worked at Bedford Borough Council in 2013, very briefly, 2011 to 2013. Whistle blew there because of stuff that was going on there. And then I set up an organisation with my friend John called Just Us in Bedford, and we just focused on getting people the assistance they were owed under the Housing Act. That resulted in me therefore having contact with a lot of people who were subject to domestic abuse. So although I had kind of encountered it before in the work I'd done, probably more than half of the cases I then was involved in involved domestic abuse in some way. Long story short, in 2016, we submitted a report to our local mayor and MP based on the experiences of people who had suffered domestic abuse and how they'd been failed by Bedford Borough Council. That led to a bunch of improvements in the service, but I'm not here to talk about that. I now do kind of casework. I do a mix of things. I do training, but I still do casework. And this is maybe an example of the kind of work I do. So this is an extract from an LGSCO decision, the local government social care ombudsman. It's obviously anonymised, and I've not even named the council here because of the level of domestic abuse that was involved. But essentially, it was a single mum, 4 kids, and long-term domestic abuse, known to Marek, kind of known to all the professionals. And she had approached her local council many times in writing because she's sensible. And the council basically left her in that situation despite having very clear legal duties to house her for a good few years. So I basically just applied the basics of homelessness law to her situation. So got her housed in social housing, her and her kids, got the council to pay £3,000 or so compensation, and got the council to commit to working towards the Domestic Abuse Housing Alliance accreditation standards. That was probably 20 or 30 hours work in total, and that may I hope it would result in kind of many more people getting the benefits of that, if the council actually sticks to it and does actually kind of get to those standards. So yeah, that's kind of my that's kind of an overview of where I'm coming from. Both Will and myself are unashamedly we're kind of on the side of homeless person, so we battle local authorities. That's kind of our bread and butter. Hopefully that makes sense. And as I say, we're not trying to say that every housing officer is a bad person, but the system itself is not functioning. And councils are breaking the law every day in situations which are obviously going to lead to people getting harmed. So that's a quick intro about me. Will, do you want to just give a quick overview of where you're coming from?
Yeah, hello. I'm a solicitor. I'm based in Southeast London. I specialise in legal aid housing work and in particular homelessness, and I've been doing this for about 30 years now. So I do a lot of this kind of stuff, and I do a live stream with Mike on most Thursdays. and that's about it, really.
Yeah, cool. Thanks, Will. Unfortunately, it's going to be mostly me talking today because, yeah, I wrote the slides basically, so it makes sense. But Will chip in here and there when I make a mistake. I'd also say if any of us, if either of us say anything really stupid about domestic abuse, then please feel free to correct us. I'm hoping we won't. But yeah, as I say, that's kind of not our area of expertise. So let's get into it. Now, again, I'm not insulting your intelligence here, but I guess it's just worth making the point that the definition of domestic abuse that we're talking about within homelessness law is the same definition used in other departments of the government. There are some weird ways in which it actually kind of hits the ground in a kind of different way. So, for example, I'll come back to it later, but the evidential thresholds for domestic abuse differ between different areas of the law, even though it's the same definition. So, very quick recap: the behaviour that's abusive must be from someone who's personally connected. Again, I'm not going to tell you what this all means because you guys know the behaviour itself needs to be abusive, which is a little bit of a circular reasoning. I think is a real shortcoming in the legislation because so much hangs on whether someone is subject to domestic abuse, but there's very, very little clarity at all in terms of, when does dysfunctional behaviour become abusive behaviour? And yeah, as I say, that can be the difference between someone getting housed or not. So it's not something which is kind of been set out very well yet. There is a textbook, just kind of flag this up. There's a textbook in theory being published early next year by Legal Action Group. Primary author is Liz Davies, which is all about domestic abuse and housing. So keep an eye out for that. I'm sure it'll be sort of 90 or 100 quid, but it will be worth it because it will be, kind of explain this stuff in more detail. And I'm hoping that that will provide some more detail as well about this kind of idea of this threshold. So yeah, there's and just to say as well, the Homelessness Code of Guidance, which is the statutory guidance for the Housing Act 1996 and the homelessness duties, still uses the term domestic violence. I don't quite understand why, but just understand when it does use that term, it means domestic abuse. So they just, for reasons I don't understand, they just didn't update it. So that's what we're talking about in terms of that kind of understanding of when does dysfunctional behaviour become abusive. Here's a couple of excerpts of people I know who kind of or people I know of who maybe say something about it. So this first quote is from someone called Sarah Ellis, who I went to a very good webinar a couple of weeks ago with, and kind of she asked these three questions to kind of discern whether it would be considered abusive. So is it a pattern of behaviour? Is it something which is making someone change their day-to-day activities, and is it making someone frightened? And then Dr. Jane Monckton Smith kind of talks about it in terms of domestic abuse. It isn't a row. It's when one person has become a threat to another. As I say, I think at this point in time, this is kind of what we need to draw on when we're approaching local authorities and showing that there might be domestic abuse involved, because there is no, if you actually look at the code of guidance and actually kind of apply a bit of logic to it, it's just a circular definition. It doesn't actually say what it is. So that's the definition. Just to emphasize a couple of things here about the way, some general principles about the law. Legal duties are things councils have to do no matter what. Now, it seems we've arrived at a point in time in England where lots of people shrug and say, there's not enough housing or there's not enough resources or whatever. And if you're willing, if you kind of go down that route, you end up completely diluting this legislation and make it impotent. The law itself is great. It's not perfect, but it's really good. It's very good at providing additional housing options to people, which can make the difference for them in different circumstances. But this case here, Remand v Croydon, just makes the point of how overriding a duty actually is and how a council has to comply with it. So it involves Croydon. The actual case itself involved a family where I think at least one of the children had a disability. Therefore, they needed a very specific type of accommodation that was going to meet the needs of that disabled child. And Croydon said, you know what, we've got like loads of people on the waiting list anyway. They all need the same type of accommodation. We just don't have it. So it went to the Supreme Court, and the judges said, I'll read it out because it's worth it. Constraints on resources are not a reason for not complying with a duty imposed by Parliament. The duty owed is immediate, non-deferrable and unqualified. The fact that Croydon may not have resources immediately available to comply with the mandatory order will reflect choices it has made in the past regarding use of its general resources. And if it does not have suitable accommodation immediately available, why should it not be expected simply to call on its general resources, perhaps by borrowing money to adapt an existing property or rent or buy a suitable property without delay to add to its stock of immediately available resources and comply with the order in that way? So, as I say, that's talking about the duties owed to a family with a disabled child. But the whole principle of a duty there is that these duties are not new, and local authorities have made political choices to get to a point where they don't have immediately available resources. It's fixable. So in Bedford, just to give you a kind of, I don't know, it's meant as a glimmer of hope, really. In Bedford, we have, our work has resulted in the council massively improving the services to homeless people. For example, the number of single homeless people in temporary accommodation went up from 10 to about 700 in a 10-year period. The council spent millions of pounds on its own temporary accommodation and staff and all that kind of stuff. So it doesn't actually take that much if you're willing to hold a council to the law and kind of willing to hold it to account in how it discharges its duties. You can have quite surprisingly good results. And just to make the point as well, if I go back a couple of slides, so the lady here, Miss J, I'd never dealt with this council before. So once you kind of get familiar with the legislation and you kind of have interactions with the same council over time, you will find that it all gets easier. But this case here involved a council I never spoke to before. I didn't have to resort to using a solicitor, but simply by complaining and kind of making a bit of a fuss that the council weren't following the law was enough to get that outcome. The next bit is ridiculously confusing, and I don't know, it should have been foreseeable that it was going to be confusing, because what we have within the Housing Act 1996 are two parts. There's 7 parts in total, but there's 2 parts that we care about, and unfortunately in many ways they're very different, but they use very similar or even identical language in both parts. So part 6 of the Housing Act 1996 is basically how it's kind of the generic pathway to getting social housing. And every area does make its own policy. So it's technically called a housing allocation scheme. They have to review it every 5 years, and they can kind of make up the rules in a lot of ways. So things like, how long do you need to live there to get a local connection? That will be locally set, and that will range between 10 years in places like Hillingdon or Dacorum, right down to no time at all if you're in other certain areas of the country. But the confusing thing is that whilst they use these same terms like local connection, there is a part 6 definition of local connection, which is locally set, so it's always going to be different. But then there's a part 7 definition of local connection, which is what we're going to come to, which is basically everything about homelessness. And a lot of people approach, a lot of survivors approach councils, and the council staff aren't well trained. And the council staff might say, how long have you lived here? And they say, well, I've just fled here. And they say, oh, you haven't lived here long enough to get local connection. And therefore they get fobbed off and kind of get, sent back to the situation they've come from. So, yeah, it is confusing, but it's important to understand this. Now, I would say if you come to this webinar today, you've obviously got an interest in homelessness and domestic abuse. I would say it's really important that you go find your local housing allocation scheme. It's literally just a case of Googling your council's name and the term housing allocation scheme, because you then get the kind of rules that apply locally to your council. There is also the allocation of accommodation guidance, which is kind of the statutory guidance for it. But there's important ways in which it kind of crosses over with the homelessness duties, and there's some areas in which it just doesn't actually make a lot of sense. So let me explain a little bit about that. So local authorities, when they set their housing allocation scheme, have to basically give some thought to domestic abuse. One of the things it says in the allocation of accommodation guidance is that housing allocation schemes must give some thought to it. Unfortunately, it varies wildly around the country as to how much thought really went into it. So in some councils, for example, the only reference to domestic abuse is the fact that they quote the fact they have to have regard to domestic abuse when they wrote the policy. So, for example, Surrey Heath is one example of many. I give that example because it just came up in casework recently, where they literally just mention it once, whereas other areas mention it a lot because they actually spent a lot of time thinking about how domestic abuse should be considered within the framework. But it gets really complicated because every area has a different policy. Every area gives a different priority to different groups of people. So you might have heard of things like Band A, Band B, Gold Band, Band 1, all those kind of things, depending on which area you're in. And a lot of policies give the highest banding to domestic abuse survivors. Now, you might think that's great, and it can be. But the problem is that in the same policy, they will give a much lower priority to homeless households owed the main duty. And I'm using a huge amount of jargon. When I wrote the slides, this is kind of how I thought logically it makes sense to go through it in this order. But so you'll get Band A if you're if you're kind of confirmed as being a survivor of domestic abuse. But then if you were to actually make a homeless application, you can potentially drop down right to the bottom band. And so Buckinghamshire has now improved, I think, but a few years ago in Buckinghamshire, as one example, you'd get band A if you were subject to domestic abuse. But if you went and made a homeless application, you drop down to band E, and then once the main duty was owed to you, you'd go back up to band D. And this created a perverse incentive for survivors to stay put in their home when really there was clear legal duties to house them in temporary accommodation and kind of go down that homelessness process. So I'm not saying every area is like that. Some areas the policy makes complete sense. But again, you need to be familiar. You need to familiarize yourself with the different policies. I don't envy anyone here today who works for a. It covers an area where there's multiple local authorities. So if you work for a county council, for example, you've probably got 5 or 10 local district councils within that area, which are going to have or have their own policy. And it makes a big difference as we'll see as we go through the day. So you've also got some policies which are discriminatory, which we'll come back to at the end. But yeah, just to make the point that if you know this stuff, if you're here looking at this stuff today, then you're probably the best person in your area to actually do anything about it. I think there's a big problem with kind of bystander intervention within the sector where we all see something bad happening, but kind of everyone assumes that someone else will do something about it. Kind of say, well, it's not my job, and it isn't your job. It probably isn't your job to make your council have a good policy. But if you don't push for it, then no one else will. That's part 6. As I say, if someone approaches the council under their part 6 pathway, and again, I'm using language which will be different in every area, and they report that they are subject or at risk of domestic abuse, then actually, legally speaking, their application for housing assistance should be dealt with as a homeless application, as I'm going to show you now. So whilst part 6 is there, and because of the way some policies work, actually someone might be better off not making a homeless application, even though legally they're homeless. That's the system not working properly rather than, kind of a good way of working, because one of the main differences between part 6 and part 7 is that part 7 of the Housing Act 1996, which is all about homelessness, has within it very quickly the interim duty to accommodate in cases where there may be abuse. Again, we're going to define that better in a minute. So the problem with part 6 is, although there are some other benefits, the problem with part 6 is there is no immediate accommodation duty. So someone potentially could get left for a long period of time. And again, just to refer back to that case at the beginning, the Miss J, this is what she did. She went onto the council's website. The council's website said, do you want some help with housing? If so, click on this link. She clicked on the link. She went through to the generic part 6 application form. She didn't know what that meant because why would she? She filled in her information. She told the council she was subject to domestic abuse. I mean, they knew anyway, but that's another issue. And they should have therefore dealt with that application as a part 7 homeless application and provided accommodation immediately to her. But they didn't. Their system itself was not fit for purpose. And again, as a kind of hopefully kind of give you a bit of optimism, this is something which has come up in Bedford Borough Council where I live, and so I kind of have a lot of contact with them. And we've raised this issue with Bedford Borough Council very simply, and they just changed the way the form works so that if someone ticks the domestic abuse box, the application will be seen by a human ASAP, and hopefully therefore be dealt with as a part 7 application if it becomes necessary, which it probably will do. So part 7, I've kind of talked about a lot there, but just to kind of, I guess, consolidate what I've just said. Part 7 of the Housing Act, it should be the process which is applied to anyone who might be homeless, which includes people at risk of domestic abuse. The statutory guidance is called the Homelessness Code of Guidance. You can obviously Google that as well. It's just a PDF. In fact, I suggest you do. And I would suggest to all of you in the webinar today that you read chapter 21, which is all about domestic abuse. It's a great chapter, really good, really well thought out. Because even within that, you'll see a lot of myths being kind of broken by the guidance. When it says guidance, by the way, it's statutory guidance. So it's telling the council how to interpret the law. It's not saying, oh, this is best practice or this is something you should do if you feel like it. It's basically telling councils how to follow the law. So if they don't follow the code of guidance, they almost certainly will be breaching the law, and that can often result in compensation claims being quite easy to get. But if we look at 18.6, so paragraph 18.6 of the Code of Guidance, the Homelessness Code of Guidance, so the Part 7 guidance, it says here that housing authorities should take particular attention to identify instances where information on an inquiry about social housing allocation scheme or an application for an allocation of housing under Part 6 provides reason to believe that the applicant might be homeless threat or threatened with homelessness, this should be regarded as an application for homelessness assistance. So this is just basically reiterating what I've just said. If you ever get into a bit of an argument with the local council, you might do well to quote this paragraph and just say, actually, when this person approached you for home, for housing assistance in general, and told you that they might have been homeless, that should have actually triggered the homelessness duties. And as I say, that can very quickly result in interim accommodation being offered very quickly. So that's part 7. But kind of just to kind of again reiterate this difference between the two parts, it seems to me, and I'm happy for someone to correct me on this, but I would say I'm pretty confident I know what I'm talking about here. It seems to me that there is a lot of misunderstandings about the ways Part 6 and Part 7 interact. The examples I've given are kind of good examples of that, where you've got an allocation scheme which treats people at risk of domestic abuse and gives them the highest banding, but doesn't at the same time realise that they are legally homeless and therefore they would be going down the homeless application route unless they expressly don't want to be. There is a bit of case law, I'm not going to go into it now, which does give people that permission to do that. But really, the way the system has been set up means that the homeless application route should be the go-to option or the default option for anyone in that situation, because there's the urgency and the immediate duty to provide interim accommodation a lot of the time. And we saw it a couple of months ago in the summer, that in July there was these new regulations brought in. But yeah, basically there's a lot of noise said, domestic abuse doesn't, local connection doesn't apply to domestic abuse anymore. And really, the reality was it didn't anyway. It never did really, because domestic abuse should be a Part 7 process, and therefore, as we'll see later on, local connection doesn't really come into it anyway. So, but the charities and the people that were kind of praising it, I wasn't quite sure if they actually understood the significance of it. So yeah, there's this kind of weird sort of way in which Part 6 and Part 7 aren't working the way they're supposed to work, for reasons I don't fully understand. But it's something, as I say, even if there is kind of some highfalutin reason somewhere, on the ground, when you're supporting someone who is currently at risk of domestic abuse, and they want to maximise the housing options, then the homeless application route, the Part 7 route, is the one you want to go down, not the Part 6. Let me just explain another kind of area which is going to often come up in casework. So the Domestic Abuse Act obviously was enacted in 2021. In the summer of 2020, when they were designing the legislation, someone did an impact assessment of the proposed legislation. So I'm not actually sure who it was that actually wrote this, but it was someone in government basically. And they said, or they made the point, that removing the vulnerability test for victims may cause local authorities to ask victims for more evidence to prove that they're legally homeless as a result of fleeing domestic abuse. The amendment could have the perverse effect of more victims being found not homeless or intentionally homeless if there is not enough evidence that they are a victim. So let me explain what this means. Before the 2021 Act came into play, you would only be in priority need through domestic abuse if you were vulnerable as a result. And that word vulnerability means something very specific within the homelessness legislation. Again, that's a topic for another time. And in one sense, one of the reasons the legislation changed was to recognise that anyone who was subject to domestic abuse will obviously be vulnerable. But the problem is that by making it an automatic characteristic, it basically means that anyone who approaches a local authority because of domestic abuse, provided they tick various boxes, that council is almost certainly going to owe them the main homelessness duty. And that may motivate councils to lie, cheat and steal to avoid having to pick up that main duty. So let me explain a bit more. In 2019, so long before this legislation was coming into play, if I was subject to domestic abuse and I walked into a local authority and said, look, I'm experiencing domestic abuse, they might say, okay, well, you don't hit the vulnerability criteria, but it's okay. I'm going to make a referral to the Marriott team through the dash form. I'm going to raise a safeguarding alert. There might be some other stuff we can put into play. So, okay, so I've not, the council's not dealt with me legally, but at least that approach is going to result in something useful. Post the Domestic Abuse Act, the moment the housing authority, the housing officer accepts that I might be at risk of domestic abuse, a whole bunch of very onerous duties kick in immediately. So they're therefore motivated to actually say that there's no abuse, or there's no proof that the abuse is happening. And so actually, they won't raise a dash form, they won't raise a safeguarding alert, because by doing so, they're admitting there might actually be a risk of domestic abuse. So this is what this impact assessment's talking about. It's saying that basically, although the legislation might seem like it was a good move, and in many ways it was, it motivated the council more than ever to deny the abuse, to downplay it, and basically not believe the survivor, which can actually have pretty profound negative effects in and of themselves. So to give you an idea, and I tell this story, this is a real story. It might sound like it's made up, but it is this crazy. So my old colleague John, who still works at Just Us in Bedford, went into Bedford Borough Council with a lady who was 30 weeks pregnant and was fleeing domestic abuse. John had already triggered the application via an email because that's a sensible way of doing it. So the council already knew the full details. They were taken into a private interview room where they sat down and explained the situation, fleeing domestic abuse, 30 weeks pregnant. And the housing officer, who was a particularly bad housing officer, one of the worst I've ever encountered, kind of looked the lady up and down, pulled out a drawer in her desk and gave her a pregnancy test and said, go to the customer service toilets and prove that you're pregnant. And John said, look, don't worry, we'll complain about this later. Let's just get a roof over your head. So she went and got the positive pregnancy test, came back with it. Housing officer shakes her head and says, nah, this isn't enough. I need to see your midwife book. So John again says, look, let's just get you a roof over your head. Let's go and get your midwife book and bring it back and show that you're actually pregnant. Bearing in mind she's visibly pregnant. And then so they do that. And then the housing officer flicks through the midwife book and says, no, I need to see a scan photo. And luckily they had a scan photo on them and she was housed and John complained about it and various other things happened. The reason I kind of talk about this is that, no, that literally happened. The complaint was upheld and the housing officer didn't last much longer. But if you can imagine how difficult it was in that situation for someone who was obviously pregnant to prove that they were pregnant, even though they didn't have to prove that they were pregnant, you can very quickly see how difficult it would be for someone who is, who's subject to domestic abuse and who doesn't have a black eye. That is kind of that basic where people are having to kind of prove something which is often, actually not very easy to prove at all. And so it's for us as professionals to be making sure that doesn't happen as robustly as possible, because it's not legal. Obviously, that whole palaver was not legal in the slightest, because the thresholds to act under the homeless application duties are very low. But that's kind of what we're up against. So although it might seem like it's better now that domestic abuse is automatically a priority new characteristic, it can have this perverse effect that it actually makes it harder to prove things. Let's kind of talk about the homeless application process now. I'm obviously going to try and consolidate what we've covered already. But just to make the point here that to be homeless legally, when it comes to domestic abuse, the actual threshold set out in Section 177 of the Housing Act. And essentially what it says is that it is not reasonable for a person to continue to occupy accommodation, i.e. they are homeless, because that's one of the kind of the proxies for homelessness, if it is probable that this will lead to violence or domestic abuse. Again, they kind of use this old school violence language against him or someone who is part of their family. And so what we get from this section here is that it doesn't really matter how severe the abuse is. It doesn't matter what type of abuse is. It could be financial, it could be physical or whatever. As long as the abuse is likely to continue or probably going to continue, as more likely than not that the risk will remain, then that person is legally homeless now. So they don't have to flee. It's not, you don't have to kind of take all your suitcases and go down to the council's housing options team. You are legally homeless already. And it's been designed by, like that, not by chance, but because by seeing it that way, by enabling someone to be homeless legally within their own home before they flee, that actually gives services a good chance to prepare and plan, and the survivor to prepare and plan for them to subsequently flee should they choose to do so. I say this because I've encountered housing officers who refuse to accept a homeless application because the person hasn't actually fled yet, but that is not the legal threshold. The legal threshold is it likely to continue in their home? If so, then they are homeless. Now, I mentioned at the start, although the definition of domestic abuse is the same across various areas of legislation, the evidential threshold for it is different. So give you some examples. If, for example, you want to satisfy the criteria for the exemption to the local housing allowance. I appreciate that's all a bit of a mouthful. So when it comes to DWP, basically, so when it comes to benefits, generally speaking, you'll need to have a letter from a professional to prove that the abuse happened. Equally, when you look at a lot of Part 6 policies that councils have, they might specify that someone needs to have a letter from the Marek chair or something to kind of prove that they are at risk of domestic abuse. But when it comes to Part 7, so the homeless application route, the threshold is very, very low. And the LGSCO, the LGO as it was back then, so the Ombudsman, they made the point in their report that followed the Domestic Abuse Act that local councils' default position should be to believe people who disclose they've been abused. So, in fact, what I might do at this point is also just bring up the Homelessness Code of Guidance, because it's probably quite good just to go and see it anyway. But just because there's a bit more to it in this, from memory, it's 21.24. Bear with me a sec. So yeah, this is the Homelessness Code of Guidance. Doesn't look very flashy, but you can just Google it. So this is where it kind of properly starts. And if we go down to 24, I'm going to be a bit embarrassed if it's not now. Yeah, here we go. So let me zoom in a little bit. So yeah, this whole chapter is well worth reading. And I'm not going to read this entire paragraph, but it is all good. But if we just go down to the kind of last part here. So in some cases, corroborative evidence of abuse may not be available, for example, because there are no adult witnesses and or the applicant was too frightened or ashamed to report incidents to family, friends or the police. The housing officer may be the first person that the victim is confided in. Housing authority should not have a blanket approach towards domestic abuse which requires corroborative or police evidence to be provided. So this again is why it's important to understand the difference between Part 6 and Part 7, because you might be in a Marek meeting with a housing officer from the local authority who is mistakenly quoting the wrong part. They might say, our Part 6 policy says there needs to be a letter from the Marek chair, when actually, according to the Part 7, which is the same across all councils, effectively, someone saying that they are at risk of domestic abuse in most circumstances will be enough to cross the evidential threshold. And it's not that housing officers can't ask for police reports or anything else. They can ask for them, but the fact that they don't exist for whatever reason isn't reason to say that the person isn't at risk of domestic abuse. I mean, many people, you guys will know, many people don't bother going to the police because the police actually can't do a lot. So they kind of say, well, what's the point? So there's various good reasons why someone might not bother going to the police. And if you're a good housing officer, it just kind of makes the point of how good a position you're in and how many good opportunities there will be to make a difference in survivors' lives by just basically believing people. So yeah, different evidential thresholds. So it's obviously nice to have a letter from the Marek, don't get me wrong. It's going to make things easy, but it shouldn't be necessary in order for someone to make a homeless application and for various duties to kick in very, very quickly. There's a lot of case law around homelessness which makes the point that local authorities should basically seek expert evidence about relevant things and should give a lot of weight to those professional opinions. So the case I've kind of mentioned here, Kelly v Westminster, is actually a case involving institutionalization in prison. But it made the point that, in that situation, the prison officer was the one who had the expertise to assess whether this guy was institutionalized or not. And the housing officer should have just basically taken that as read. So the same principle, as again, you see it in a lot of cases involving medical issues. But a council should be, if there is alleged to be domestic abuse involved, they should be seeking as much information as they can do. And if they therefore wrote to an IDVA or a domestic abuse professional, and that professional said, yep, I think this person's at risk of abuse, unless there is a fantastically good reason to ignore that professional's opinion, then that should be the way the housing officer proceeds. They should proceed on the basis that the evidence from that professional is good. When you are involved in a survivor situation and you are, even if you haven't been asked yet, if that person wants to make a homeless application, then you want to, if you want to write a supporting letter, you want to focus on, among other things, you want to focus on, do you think there's abuse involved? Do you think it meets the definition of domestic abuse? And do you think that abuse is likely to continue if that person remained in their home? As I say, there's other things you want to worry about because there's, you're not just dealing with homeless applications, but that assessment needs to be reasoned, and the kind of more logic you can put behind that, the better. So if you say, for example, I'm working with Joe Bloggs, I think they're at risk of domestic abuse because there's been a pattern of behaviour over time, and the incidents appear to be escalating in severity. Therefore, I think that if this person remained in the home, they would be continue to be subject to domestic abuse. You want to give that kind of level of kind of thinking behind it. It would be very difficult for a housing officer to dismiss that, really, unless they knew something about, maybe that person's a convicted fraudster and they've done it 5 times before or something. But as we know, the vast majority of people will tell the truth about this stuff. So that's kind of what you want to focus on. As I say, there'll be other things you want to focus on as well, because it's not just one thing you're doing. So yeah, just someone's making the points there that notes of a consultation from GP about domestic abuse disclosure is useful. Yeah, exactly. So in my experience, although people don't need, they don't need any evidence in theory, their word should be enough. It is often possible to get evidence from somewhere. So I remember a case where I was really scratching my head because there wasn't any evidence anywhere, but actually it turned out that the lady had disclosed the abuse to a like a preschool worker, a couple of years before or something, and that kind of substantiated what she was saying, and that kind of made it easier. But as I say, legally speaking, you don't need it. It's helpful, and in the real world, it makes it much smoother. And if you guys are involved, I would assume that you'd probably be able to give that sort of level of evidence anyway. But it actually shouldn't be necessary from a legal point of view. That's the definition of homelessness. So let me go back a step slightly. When you make a homeless application, there's basically 5 tests that you'll be tested against. The first is whether you're homeless. So we just kind of cover that. If you're in your own home, but living in your own home is likely to result in domestic abuse or further domestic abuse against you, then you're legally homeless now. You don't have to flee. So that kind of crosses the first of those 5 tests. We've then got eligibility, which I feel like I could have written more about this on this slide. But basically, eligibility is something like having recourse to public funds. It's not exactly the same, but I don't know what the differences are, to be honest. So generally speaking, if you have somebody who's not eligible, then there is basically no housing assistance available from the council under the Housing Act. There might be other assistance available under a different act, Children Act or the Care Act in theory, but people who are not eligible won't be able to get housing assistance unless they qualify for the destitute domestic violence concession, which is, and again, this is something where probably most of you know much more than me will do, but where you have someone who's here on a spousal visa and they're subject to abuse, they basically get a short period of, they're treated as if they're eligible, basically. Again, I've not really seen that work in practice. It's just something I've referred someone onto before. So again, you guys might know more than I do. But in one sense, there's never anything to lose, really. Oh yeah, so yeah, someone making a point that it's now called MVDAC. If someone's given a link there as well. So thanks for that. Yeah, so as I say, I'm not my area of specialism, but there's nothing to lose by making a homeless application in the sense that it doesn't cost anything. So even if you think someone's not eligible, the worst thing that can happen to them if they make a homeless application is that they get some advice and assistance, which still might be quite useful. And that advice and assistance might be details of other organisations that would be able to help people who are not eligible. So question coming in here: if a victim survivor of domestic abuse has been coerced debts like housing, council tax arrears, is there certain legislation or guidance that can be quoted that can be used to advocate so they're not assessed based on the economic abuse they've experienced? So really good question. So I'm going to give half an answer. I'm not quite sure if I'll be able to give a full answer. And again, I'll actually give an example of my old colleague John at Just Us. And John was involved in a case another case involving domestic abuse, where the survivor had been subject to economic abuse over many years. That had in part resulted in rent arrears accruing. And the council owed them the main duty because rent arrears doesn't actually have anything to do with the main duty in most cases. But the problem is that now that the main duty had been accepted, so Bedford Borough Council doesn't have its own housing stock, so they had nowhere to actually house this family. And they referred to a housing association called Stonewater, which you may have heard of. It's a fairly large housing association. And Stonewater came back and said, there's rent arrears on the account. We won't touch this applicant. And John being John, immediately complained to the chief exec of Stonewater, the MP, the chief exec of the council, and Stonewater changed their policy immediately as a result of that complaint. Because he made the point that this clearly you can't have a blanket approach towards you can't have blanket approaches in general, But you can't have a situation where someone may have, it may be out of their control that they accrued rent arrears, and yet kind of actually end up essentially discriminating against them in that way. So that's half an answer. So I think any policy that basically says all rent arrears, we won't help, I think would potentially be seen as discriminatory because the majority of survivors are female. It would potentially be seen as a kind of a discrimination against the protected characteristics in that case of sex. So that would be something you could throw at it. You might also find stuff in local policies because actually a lot of local policies have been written pretty well. So there's actually quite a lot of good stuff in them. More than that, Will, I don't know if you've got any bright ideas about this one. But in terms of just kind of, is there any kind of legislation? I can't think of any off the top of my head, but it might come back to me in a minute. So Will's shaking his head as well. But certainly it's something you always want to challenge on. So in one sense, there's the law, which is great, but you've also got common sense and common decency, and clearly a policy which is excluding people who are innocent should be challenged anyway. And I don't think you would necessarily need to quote a bit of legislation to win that argument. That, yeah, one side about eligibility, I don't know a great deal about it, if I'm honest, because it's not generally something that comes up in a lot of my casework. Priority needs. So we've talked about the legal definition of homelessness. We've touched on eligibility. The biggest thing probably is this kind of idea of priority need, and I've already mentioned it several times, because you are automatically in priority need if you are homeless because of domestic abuse. And that might seem great, and it is in most cases, but that it does actually allow a couple of weird exemptions from that. So the wording of the law, as I say, is if you are homeless because of domestic abuse. So you might have had your own home, you might be living in your own home, you might have owned it outright, but you were at risk of domestic abuse. That made you legally homeless even before you fled, and that in itself would therefore make you immediately in priority need. So that's good. That catches most survivors, but there will be people you work with sometimes who fall outside of that definition somehow. Give you a couple of examples that I've seen before where street homeless couple, they both become homeless for other reasons. They then formed a relationship on the streets. There was then domestic abuse, made a homeless application, and the council kind of said, well, they're not homeless because of domestic abuse. She was already homeless. But that's the way the law's written. So in that case, you would be relying on the idea of vulnerability. And as we know, domestic abuse by nature is going to impact on people's resilience. I'm not going to define what vulnerability means because it's very complicated, but basically, really anyone in that situation would still be in priority need. Equally, you might have a situation where you've got someone who leaves their home because of domestic abuse. They move into a supported accommodation unit somewhere, YMCA or something. They break the rules. They get into an argument with staff or something. They're then kicked out, and they can make a homeless application at that point, but they're not going to be automatically in priority need because the reason for them being homeless is not the domestic abuse. It's the fact that they broke the rules of the YMCA. So so the argument still can be made. And as you guys all know, like the vast majority of people who are subject to domestic abuse will be drastically affected by it anyway, and will probably, will often have other associated vulnerabilities attached to it. So it might be disabilities, it might be language barriers, it might be historic trauma. Those kind of things would all often kind of play a part in it, and all of those things would still be relevant to the idea of priority need. So that's the first three of the 5-part test. And if we just draw them together for a moment, Section 108 is one of the only sections it's worth actually remembering about the Housing Act. A lot of it, you never actually really see in practice. But Section 108 is the interim duty to accommodate. And as 15.4 of the Code of Guidance explains, it kind of paraphrases it, makes it a bit more easy to understand. It states that Section 108, subsection 1, requires housing authorities to secure that accommodation is available for an applicant and their household if they have reason to believe that the applicant may be homeless, be eligible, have a priority need. So grammatically, you read that paragraph, may be homeless, may be eligible, may have a priority need. It's a low threshold. I could quote case law till the cows come home about how low that threshold is and how councils almost, or very regularly basically applied too high a threshold. I'll give you an example from the LGO in a little bit. But as we can see with domestic abuse, most people will be homeless because of domestic abuse. If they're eligible for assistance, as in they have recourse to public funds, they will also be in priority need automatically. So immediately the council would have a duty to provide interim accommodation. I can't tell you the case law that proves this, but that isn't just an offer of like a referral to a women's refuge. or a men's refuge. The council needs to actually offer accommodation itself. But as I say, there's actually surprisingly woolly when it comes to that. But yeah, certainly, yeah, when someone approaches, if the council's only action is to say, "Oh, we can refer you up to a refuge up in, kind of Durham or something," and you're from Cornwall, that is not going to be a discharge of this duty. But this is kind of, yeah, this is where it becomes useful. Now, obviously, I appreciate that not everyone who's subject to domestic abuse wants to make a homeless application. There may be other measures that can be taken, non-molestation orders. There's a number of other things they could take, and there'd be good reasons for them not to want to go down this route. But I guess my experience is that by kind of knocking on the door of this process, you create a kind of more options for that person, which is a good thing. Even if they say, actually, do you know what, I don't want to make the homeless application, I want to stay put and kind of figure something else out. It's always a good option to have, and it also focuses the minds of professionals, particularly councils, when it comes to pursuing other things, because interim accommodation costs money. So if you have someone who's basically making use of interim accommodation, it's probably going to result in other kind of things being done to kind of help that person out so they're no longer homeless. So yeah, that's interim accommodation. Again, there's loads more to say about that. It has to be suitable. We'll talk briefly about location in a little bit, but certainly location and suitability of interim and temporary accommodation is quite difficult to challenge. Say a couple of other things as well. I've mentioned again yet more jargon there, just to make the point that interim accommodation is the accommodation you get between making a homeless application and the final decision being reached, which usually should only take a couple of months. And then temporary accommodation is where you then stay from the decision being that you're owed the main duty through to you actually getting your settled accommodation at the end of it, which can be many years, particularly in London. So local connection, again, is massively misapplied, not just within domestic abuse cases, across the board, really. It's probably the number one way that councils try and gatekeep people. I've not even used that term yet. So gatekeeping is when you unlawfully deny someone housing help. But just to make a couple of points, so legally speaking, irrespective of domestic abuse or not, if you're homeless, you can approach any local authority in the country anyway. But pragmatically speaking, in most cases, you'll only end up getting referred back to your home area. But the issue of safety then quickly crops up. Let me just go back to the chat just to get the question. So, yeah, a really good question. So I was wondering what suitability looks like in practice with interim accommodation. I have a client that's been placed in hostel that also openly advertises that they house sex offenders, which doesn't seem suitable. So I can't quote it off the top of my head. I'm sure there's stuff out there which talks about that survivors should not be put in mixed sex accommodation. There may be a series of questions, by the way, that I need to just kind of figure out and kind of somehow communicate to everyone after the event, by the way, because that might be one of them. But certainly, I mean, again, suitability is kind of, it can get quite technical, but it's still kind of everyday common sense. And clearly someone who's been traumatized in whichever way by someone else, then clearly there's going to be considerations that need to be had around the suitability of shared accommodation. I mean, it's not exactly answering the question, but within the local housing allowance exemptions for under 35-year-olds, if you have ever been subject to domestic abuse since your 16th birthday, you will automatically be exempt from the shared accommodation rate. So even if you're 21 or something, you will get treated as if you're 35, and you'll get the one-bed self-contained level of LHA. So you can see within that kind of area that clearly they recognise that importance of not being placed in mixed sex or kind of even same sex, to be honest, sometimes in that type of accommodation. So yeah, it definitely isn't suitable, or definitely doesn't seem suitable. I'm not quite sure if I can say anything else useful at this point in time. So local connection, just again going back to basics, as I've already said, Part 6 and Part 7 both have something called local connection, but they're very different things. But when it comes to domestic abuse, you can't be referred back to an area where you're at risk of abuse. So I'm from Bedford. Let's say that my whole family lives in Bedford. My job's in Bedford. My entire local connection is to Bedford. And let's say I was subject to domestic abuse. I can approach any council in the country. Let's say I go to Milton Keynes. I say, hey, Milton Keynes, I'm experiencing abuse in my own home. Can you help me out with housing? I'm a British national. By saying those three things, I've essentially satisfied Section 188. They then should place me in interim accommodation immediately. They then sit down for an assessment with me a few days later in practice, or a few weeks in practice sometimes, and they will probably, well, they will figure out that I don't have a local connection to Milton Keynes, but I do have a connection to Bedford. However, they can't refer me back to Bedford because there is a risk, or assuming there's a risk of abuse or continued abuse in Bedford. So in effect, Milton Keynes in that example would be stuck with me going forward. They would be the ones that owe me the main duty. So there will be situations where you can apply. Well, yeah, someone would want to apply anywhere they want. Yeah, somewhere else in the country. There's also nothing stopping you approaching the same local authority that you live in, that you have lived in, that you have a local connection to, because whilst you might be at risk of domestic abuse, your kids might go to school there, your job might be there, your whole family support network might be there, and therefore, on balance, it's going to be better for you that you remain in your home area, despite the fact there will be some level of risk. I would love to be able to tell you the bit of case law on this that makes this point. I know it exists. You have my word that it exists. I just can't find it. But there is a case which explicitly looks at that issue, where someone applied to their own area. That council tried to house them somewhere else. Tried to house them 100 miles away or something, and they dug the hills in. And ultimately, that council had to house them in suitable accommodation, which basically incorporated this idea of being near to their support network. If you ever get into an argument with the council about this, you want to quote this paragraph here from the Code of Guidance. So, in fact, I'm going to read the whole bullet point because I can't remember what I said. So, yeah, don't worry about section 189A too much. So, yeah, there's strict conditions for referring someone back to their home area if there's domestic abuse. And so 10.51 subsection C of the Code of Guidance says that one of the conditions is that none of them will be at risk of domestic abuse or other violence or threats of domestic abuse or other violence which are likely to be carried out in the district of the authority to be notified. And legally, that's basically saying if there's any risk, really. It doesn't say there's a particular level of risk. It just says if there is a threat or risk of domestic abuse, then they can't be referred back there. And if, in that example I just gave a minute ago, if Milton Keynes tried to refer me back to Bedford, Bedford could just basically say, nope, we're not going to take that referral. There's a risk of abuse here. And that would have basically allow me to apply to any council in the country. And we're going to give you a bit of useful resource on that in a minute. So before we do that, though, let me just kind of make the obvious point that, this shouldn't need saying. You can't be found intentionally homeless if you're at risk of domestic abuse in your property, in your home. I laugh, but it's terrible, really. One of the easiest compensation claim I ever got for someone was where a survivor went into a council. They explained they were experiencing considerable abuse, and the officer recorded in their notes that they advised the client that although she was experiencing considerable abuse, if she left her tenancy, she'd be making herself intentionally homeless. As I say, very easy compensation claim to get for her. And we did get housed kind of a month or so later. But to give you the legal reason to be intentionally homeless, the accommodation you lost or you left must have been reasonable to continue to occupy. But as we've seen in the definition of homelessness, if you're in a accommodation, but it's probable that that resulted in further domestic abuse, then it's not reasonable to continue to occupy. So that's where we get our kind of, our legal definition of why you can't be found intentionally homeless. But again, it's one of those ones where it's like just common sense should prevail. I'll just say it one more time. You cannot be found intentionally homeless from accommodation where you are at risk of abuse. And that's non-domestic abuse as well. It could be any type of abuse. So yeah, hopefully that all makes sense. So that's a whistle-stop tour of the 5-part test. Let me talk about the average waiting times document. So let's check the chat as well. So just to clarify, I'm going to put the slides and a couple of other documents into the chat before we go. So that's the best way to get it to you because Eventbrite doesn't allow me to send stuff out, I don't think. And just to say that, I'll read out the comment just because it's worth probably saying a bit more about it. I've received so much pushback from councils saying that victim survivors are making themselves intentionally homeless, so relevant case law and guidance will be helpful. So, I mean, the law itself on this is not terribly difficult, but there's a danger that I make it sound really easy to challenge the council. The reality is I've worked with housing officers or butted up against housing officers who are thoroughly unpleasant and just won't budge. And in my experience, the only way to get them to budge is to go through the complaints process. So I'm going to go back to the slide from earlier in the session. Miss J here, it wasn't straightforward. Although it only took 20 or 30 hours in total, When I first got in contact with the council and said, "You've got an immediate duty to house this family, what are you doing?" They basically said, "No, we don't." And so I had to go through the complaints process to get it sorted out, and well, in fact, had to get to the local government social care ombudsman, which means I had to exhaust the complaints process before they would. Well, I say that it got to stage two, and they started to actually house. Yeah, they actually kind of housed her. But yeah, the first time you deal with the council, they will push back, and you know, there's not a lot of. I've had very little success in getting a individual housing officer to follow the law once they've said something stupid like, "Oh, you know, they're going to be making themselves intentionally homeless." There is going to be a battle, and it's not pleasant. And you probably have some political considerations to worry about as well to make it even harder. But yeah, but the in one sense, the law itself is good, and it's about being methodical. So if a council officer says something like that to you, your first thing really should be to say, "Let's have that in writing, please." And once you've got it in writing, if they're going to dare to say that in writing, because it'd be pretty foolish, but it does happen, obviously, you've then got a little bit of time just to go back to the code of guidance. Again, it's all in there. You can quote the guidance, and ultimately, you're probably going to have to do that as part of either a formal complaint or by escalating it to the manager, depending on what your relationship is with your council. So, yeah, it shouldn't ever happen. Shouldn't happen. It does happen. It's down to people like us, you know, as in all the people coming today, and you know, people like me and Will, to push back on councils. In Bedford, my experience is once you've done it a few times, it gets really easy. So in Bedford now, if I go into the council with someone, I don't have to do anything. Just the fact that I'm there and the fact they know I'm awkward and I'm not going to, you know, kind of tolerate sort of illegal stuff, they'll just follow the law. So, but it does, yeah. The problem with this stuff is that the first battle you have with the council is always the hardest, and it can feel very hopeless and incredibly stressful. So, as I say, I don't want to make out like it's really easy because it's not. But yeah, okay. So, average waiting times in England. There is. I did this exercise about a year ago, where I did an FOI request to every single council in the country. There's more than 300 of them, and I asked them for their average waiting times for people owed the main duty. Now, there's a lot of caveats with this, so I'm not going to be able to give you every single like nook and cranny of what this is about. But I'm hoping I can give you some useful stuff. So if I go to here, so this is again a document I'm going to put into the chat close to the end. If you're going to use these figures, you must watch the video on the YouTube channel, which is this link here, because it explains what the caveats are with this information. If you go off half-cocked with this stuff, you can end up causing people a lot of problems because it's quite easy to misinterpret these waiting times to be something else. But this is the average waiting times owed to people owed the main duty, which are going to include a lot of people subject to domestic abuse. And crucially, as we can see from this map, although we can't see very well from this map because it's a bit of a small map, the average waiting times vary massively. In fact, let me just go back to the slides just to show you that map in more detail. So again, it's not the best of a view. It's pretty terrible. But effectively, the dark red areas are where the average waiting time, in this case for a two bed, but you can see the same pattern in other bedroom sizes, is over 3,000 days. So lots of London. You're looking at, you know, Croydon, for example, for a one bed, I know is 5,500 days average waiting time. In other areas of the country, it's less than 50 days. So in Basset Law, literally the average waiting time is 6 days. That is legit as well, because I went back to them and said, surely it can't just be 6 days. And they said, no, it is. So this map here gives you an idea where I appreciate this doesn't apply to everyone, but where you are working with survivors who want to be somewhere else, they want to flee their area, then these average waiting times can be very useful. I give you an example earlier this year in Bedford. So I assessed a lady who was fleeing from London. She was literally about to give birth. She was like 9 months pregnant, pretty much. And she approached Bedford Borough Council, who had an immediate duty to house her. But there was nothing that tied her to Bedford. She just came here because she vaguely knew someone. So I sat down with her and said, look, you can apply to Bedford. They'll owe you the main duty. The average waiting time for someone of your bedroom size is going to be like a year and a half or something. But however, if you want to apply to central beds, which is nicer, you've also got a shorter waiting time. Do you want to do that instead? And she was like, hell yeah. So we went to central beds, made the homeless application there. Yes, there was some pushback, but it got ironed out. And the main duty was accepted 2 months later. And she will probably be housed by now, to be honest. So if you're working with someone in that situation where they just want to be somewhere else, these figures can be useful. If I go back to the other slide just to show you the figures. So we've got every local authority. As I say, some local authorities didn't even provide the data because effectively they couldn't be bothered, but most local authorities did. And again, so this column here is 1 bed, 2 bed, 3 bed, 4 bed, and so on. So in Haringey in London, for example, average waiting time for somebody who needs a 1 bed is 521 days. So that's, in fact, that's a bed sit. But yeah, so let's go back at the top here. So yeah, here's the columns. So some gave separate waiting times for bed sits rather than 1 beds, but you can see how much, again, just how much they vary. So Hartlepool average waiting time for a 1 bed 84 days, whereas Hounslow 630 days. As I say, lots of caveats with that, but I've used this information with its limitations to get some good outcomes for people. So we're going to share that in the chat in a moment. And get the slides back up and running. So that's the average waiting times. And then, in fact, let me just jump ahead slightly. We'll come back to TXV IDA. So the local government social care ombudsman is a fantastic resource. That is where I learned housing law, because if you subscribe to the newsletter every Thursday lunchtime, you get a bunch of updated decisions basically, and they explain what the law is. So, but yeah, here's some examples of local government social care ombudsman decisions. So this one here, which involved Redbridge, again, I'll put a few of these links into the chat just so you can have a look yourselves. This one was Redbridge. In this case, the LGO said that the council was at fault for refusing to accept a homes application from Miss X when she fled domestic abuse to its area. The council's housing allocation policy is flawed because it excludes a group of applicants the law says must be given reasonable preference. The council was also at fault for failing to tell Miss X about her right to review its decisions. We're going to come back to this issue in a moment because there's some other stuff to say about this, but just some other examples as well, again, just to give you a feel of what else is in there. So this one here, I'm not even sure which council this was. Again, I'll put the link in the chat if you want to have a look for yourself. But in this case, Miss X complains about the council, how the council dealt with the homes application. The council is at fault as it failed to properly consider the risk of domestic abuse to Miss X when she made a homes application, failed to provide interim accommodation, delayed in dealing with the homes application, and wrongly focused on sustaining Miss X's tenancy, which was unsustainable. As a result, Miss X and their children lived in unsuitable accommodation for longer than necessary, which caused significant distress to them. Miss X may also have missed an opportunity for settled housing. Blah, 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 £2,500 compensation. And then this one here, again, very similar. Miss D says the council left her in unsafe temporary accommodation. So she was put in temporary accommodation, which the perpetrator knew about and continued the abuse. And again, I'm not going to read the whole thing out because you can read it yourselves, but she got £4,500 compensation. So these LGSO decisions are excellent, not only at understanding the law more, but also just kind of like reassuring your own sanity, because when you're having an argument with a housing officer and they're telling you something which you kind of are pretty sure is wrong, but you're not an expert, so you kind of take their word for it, and it can be very disorientating. Some people would call it institutional gaslighting. The LGSO can be a real kind of like sanity check. So this is a document I've compiled. Again, I'm going to share it in the chat, which is hundreds of LGSO decisions, and these are all available on their website, don't get me wrong. But the thing that I've done here is added in keywords which enable you to search for a particular term. So if we search for the term domestic abuse, there's a whole bunch of terms that come up. So there's the summary there. And what you can do is you can take this number here and copy and paste it into the LGSO decision database, which is literally just lgo.org.uk/decisions. You stick the reference number into the box and you get the full decision here. And that this is a full decision basically. So it gives you the summary, it gives you the remit of the ombudsman, it kind of tells you anything that falls outside the investigation. It tells you what the law is. As I say, this for me was like, kind of just helped me realise that I wasn't going insane. Talks about the kind of different areas of law that will kick in. It says what happened and basically says why they got compensation or potentially why they didn't get compensation if the complaint wasn't upheld. So that database there, I would say, is another really good way to familiarise yourself with housing law and homelessness law, because it's just good to see how things work in practice. And as I say, the ombudsman, although they're not kind of like, they're not a statutory organisation by definition, they do know what they're talking about, and they can in effect tell councils to like pay compensation. So TXV IDA, it's a bit of a sparse slide here, and I will might fill in some gaps here. But basically, this was a case from a couple of years ago where, if I remember correctly, and I might not remember the details exactly, but you can Google TXV Ida. Basically, this lady had been subject to abuse in Brighton, I think it was. She'd approached Ida Council. I think she ended up getting housed in Hastings for a bit or something like that. I can't remember exactly, or somewhere near there, like Lewis or something. And effectively, the council said, you're barred from the housing register because you don't have local connection. And it went to court, and effectively, the policy itself was seen to be discriminatory because the majority of survivors will be female. By having this local connection kind of criteria in it, which would exclude survivors who were fleeing areas, it would cause a disproportionate number of females to be negatively affected. And so the policy itself was found to be unlawful. And again, actually, we touched on an example there involving Redbridge, where again the policy itself was unlawful. So the reason we're just going to flag this up, and I don't know if Will wants to add a little bit more to this, the detail there, but certainly you can Google it and kind of read up on it yourself. But yeah, but basically, again, you may well have a policy, a local housing allocation policy in your area, which is not fit for purpose, and no one else is going to challenge it. So if you know about the policy being unlawful, you should not be afraid to challenge it robustly, politely, but robustly, because by doing that, you can actually get policies to be improved significantly. And that then has a knock-on effect to a lot of other people that you probably will never meet, but it's still a good thing to do. I was going to catch up with the chat. There's a couple of questions we've got coming in here. So, how do we stop our service users bouncing around temporary accommodation from council to council as they've not supported them into any long-term accommodation? Apply to Locata or their equivalent. So Locata is like I think Ealing's the main user of Locata, but I think there's other councils that use it. Will might give a different answer to this because he's a solicitor and I'm not. But my answer to that would be is that you should use the complaints policy without any patience at all. As soon as you think the council's not doing something right, as in leaving someone in temporary accommodation for too long without any support, or in leaving an unsuitable temporary accommodation, you should just complain straight away. As uncomfortable as that probably is, because I genuinely am not an adversarial person, believe it or not. I don't like doing it. It's very stressful. But unless you're willing to do that, then nothing will change. Not only for the individual, but it's kind of a wider policy as well. So in a situation where someone has just literally been left in limbo in temporary accommodation, there's a good chance something's gone wrong. Now, I say that in London, it's not unusual to be waiting in temporary accommodation for 15 years. So, the whole idea of temporary accommodation is it's a bit of a misnomer. But in other areas of the country, it shouldn't take that long at all. I'm working in a situation involving someone who was housed by London Council in Bedford, has been in Bedford now for 8 years. And actually, my first job with her is to figure out what duty she's been housed under, because I'm not even sure. She's not even sure. And so actually, there's quite a lot of untangling you have to do to actually work out what actually the council should be doing at this point anyway. But it is technically possible to be in temporary accommodation for a long, long time before you actually get your final accommodation. So I'm not sure if that's a terribly kind of reassuring answer there, but I think in short, you want to complain and you also just want to work out exactly what stage the application's at. It's not, we kind of hear quite regularly about cases where someone's been left in relief duty for like over a year, when really it should only be a month in total, 2 months in total, if the council's doing things properly. Will, did you want to add anything to those questions at all?
Yeah, the only thing, well, this is just about the issue of how do you stop ending up in sort of temporary accommodation indefinitely? And I don't want to sound negative, but it's still a sort of it's still a belief that there's a right to permanent accommodation at the end of this process. And unfortunately, there isn't. And the belief goes back to before 2012, when the Localism Act 2011 came into effect. Before that, the rule was that when a council accepted a duty to a homeless person, they could only discharge that duty by giving them social housing. That would be housing association or council accommodation, which to all intents and purposes is permanent, in that you're not going to get evicted as long as you behave yourself. But then they basically ran out of that sort of accommodation, and the government said it was okay to give private sector accommodation. So the only duty they have is to provide suitable accommodation. So it could be that that accommodation is private sector, and it could be that they you could only be there for a couple of years. I mean, you may be there for a long time, but the problem is to manage people's expectations. And so if people are saying, well, where's my offer of permanent accommodation? The answer is, well, you can apply to the housing register, but you'll just have to join the queue there. Um, and unfortunately, you're not going to get a permanent offer through a homelessness route as of right. You may end up with one. You may be lucky in that they could offer you private social housing, but they don't have to. I'm sorry if that sounds negative, but it's something that I often have to tell people early on or late on if they haven't got the message.
There's a question that kind of is along the same lines here, Will. So just basically talk about someone who's been in temporary accommodation for 15 years, where you've got five members of the family, including four children in a one-bedroom flat. So all accommodation offered by council has to be suitable.
Yeah, yeah.
And again, there's no kind of like exact science to things like overcrowding. But that seems to me like someone living, yeah, living in that situation, that is likely to be unsuitable and so very much worth challenging. This person had actually been escalating to the ombudsman, which is a very good move because again, although the ombudsman doesn't tend to like kind of recommend large payments generally, when it comes to unsuitable temporary accommodation, it's actually one of the areas which is the easiest to get kind of quite high awards. So yeah, good luck to that person to see how it goes. Again, it's just a case of being methodical and being very patient because once you get through the council complaints process, it can take months more than it should do, and then you've got to refer it to the LGSCO, and they can take even 3 months just to pick it up and even look at it, and then can take several more months to actually make a decision. Another comment here: so our local council always pushes for private rented and never offers TA. So as Will just said, councils can use private rented accommodation provided again it's suitable and of a reasonable standard. So you can't use slum landlords for it. But councils can discharge the main duty into private rented accommodation. But just to make the point I said earlier with the Croydon case, a council saying they don't have enough housing and never offering temporary accommodation is probably the very definition of illegal conduct. Again, if this person joined the webinar late, go and have a look at Google Imam v Croydon and look at that judgment and look how the judges considered Croydon's argument that they didn't have enough money. That it just kind of it held no water basically. And again, I mean, again, it's political choices. They councils, even the most cash-strapped councils, have political choices, but unless you're willing to challenge them, they'll get if they get away with it, they'll get away with it. In Bedford, they always said there wasn't enough money to house people, and yet they suddenly pulled out 700 temporary accommodation units for single homeless people. It can be done because the law is very, very powerful as long as you're willing to use it. So I've just looked at the time. There's maybe a slide or two I just want to finish on, and then I'm happy hanging around and just taking questions as they come up. Will, if you've got to go, that's cool. But just to finish up, kind of consolidate what we've talked about. I'm hoping we've introduced some things here which are useful, and I think if nothing else, if you hear nothing else from today, it's worth just understanding that the law is good, but to get a council to comply with the law requires you to kind of actually to take them to task. And if we circle back to this case that I mentioned at the start here, so Miss J, 4 kids, long-term domestic abuse, a whole raft of failures from statutory services and local services. I could try and give a bit, kind of bit of a different angle to this story. When I first picked up the case, as I say, I was going about this sort of stuff, and so I was talking about this sort of stuff, and she kind of picked up on it and said, "Hold on a minute, my council's saying that I need a certain amount of evidence, and before they can do anything, and that they need certain documents before they'll do anything." And I explained to her that's wrong. So I then got involved and took her on as a kind of an actual bit of casework. And whenever I take a case on, as I'm sure many of you do, the first thing you do is you need to kind of gather some information to figure out what's really going on, because it can all seem like a bit of a mess and a bit of a tangle. So I rang up the IDVA and I said, okay, look, Miss J is basically asking me for help. It seems really obvious that the council's got a duty to house her. Why on earth is no one doing anything? And the IDVA said, oh, that's just our council. They just don't, they don't really follow the law that often. And I could kind of hear the shrug in her voice and the IDVA's voice. And, oh man, I don't want to sound like an absolute nightmare. That really annoyed me. I'm not trying to be difficult here, but it really annoyed me to hear that an IDVA who was paid to support this lady was just shrugging at the local authority systemic failures, which are probably affecting many other survivors in the area. And I think that's the, we can kind of get ourselves into a position where we just shrug at the local authority breaking the law. Again, if you're not going to hear much else from the webinar today, I'll just say that it's worth fighting for. It's worth, it does take a fight. It isn't easy. You kind of often have to escalate things. It's very uncomfortable. In my opinion, it's absolutely worth it. So that's kind of like what I wanted to say, just to kind of finish up the formal section of this webinar. As I say, I'll hang around to take further questions. But yeah, I'm hoping we've kind of piqued your interest in terms of just getting to know the law better, because there's so much good stuff within it, and it is very powerful if only we just dare to kind of hold councils to account. And as I said earlier, the first battle you have with the council is always the hardest, but it does get easier. Once you get a win under your belt, it starts getting much easier. But it is worth doing. So, final thing from the slides, we'll mention a couple of resources just to say. So I run regular training on this stuff. The next introductory course is a day-long course online, which is on the 5th of December. If you use this discount code, or whatever you want to call it, DA webinar, you'll get 20% discount on tickets. So there's the code, and if I find the Eventbrite, in fact, you've come through Eventbrite. So if you just go back to the Eventbrite page, you'll see the upcoming dates, and as I say, there's a discount for the 5th of December date. Me and Will and two of our colleagues, Shannon and Karis, run a weekly live stream on the YouTube channel. So if you have questions going forward, you can email us, but we probably won't respond. But we might take the question anonymously to the next live stream, or you can come to the live stream and actually ask it there. Again, it'll all be anonymous, but it just gives us the space to actually unpack these questions in a bit more detail, because trying to give a written response to quite technical and quite complicated situations can get very time consuming, if nothing else. Will's compiled a list here of solicitor firms that take legal aid for housing cases. So have a look at that. Again, solicitors can make things very easy. In most cases, you don't actually need one, but it does certainly help to win an argument with the council, particularly if you're in London. I didn't make that point yet, but London councils, particularly the worst London councils like Ealing, Croydon, Tower Hamlets, Lambeth, Redbridge, Waltham Forest, there are others as well. Generally speaking, unless you've got a threat of judicial review coming from a solicitor, they don't like to follow the law at all, really. But outside the M25, it's a completely different story. So you've got a good chance of getting a good outcome outside the M25 at least. Also, we're on a Facebook group, so if you want to ask anonymised whatever questions, use the Facebook group. Again, you'll get quick responses. I've said all that. So yeah,